Hello again to all the warriors for justice out there who are righting wrongs and upholding our greatest American freedom, the right to an unfettered and unlimited trial by jury of your peers. I'm your host, Rafe Foreman, for this podcast brought to you by the original Trial Lawyers College. We're going to talk about an issue today that involves sexually explicit cases. And if this is a trigger for you or if you're uncomfortable, we want to put this warning out before we start this podcast with our guest, Karen Lindholdt, today, so that you may make whatever choices are appropriate for you. Hi out there, TLC land, and welcome back to the podcast. Today we have a dear friend and special guest, Karen Lindholdt, who hails from the state of Washington. She's a TLC graduate in the class of 2009, but I think I first met Karen at Sleeping Lady, which was a TLC regional that we still hold in that location. Is that your recollection, Karen?
That is my recollection.
What year was that?
That must have been 2008.
Oh, okay.
Yes.
Well, for those of you who have not been to Sleeping Lady, it's a Bavarian village up in the mountains in Washington State. And it's a great regional, and I'd encourage you to look that up on the website and attend there. Karen is a member of, I don't know what you call it, the TLC West. Is that what you told me today on the phone, the TLC West local group?
It's called TLC Northwest.
Okay.
And it consists of Washington, Oregon primarily.
Yeah.
But it's a very active group in Seattle.
Well, and you were telling me some great things about some of my friends that are in that group with you, and some recent work that you all were doing on cases. So it's going well, huh?
Yes, it was really amazing. People, due to COVID, aren't meeting a bunch, but I had a murder trial that was scheduled to begin December 15th. And I was nervous about a couple things. One, I hadn't been in trial for a couple years due to COVID, and I felt a little bit rough. And so David Lacrosse hosted down in Port Orchard. We didn't have a psychodramatist. Mark Wagner worked as the director, and we focused on my opening and on my voir dire. And as always, it was incredibly humbling. The first one I did was a disaster, and people were honest about it. And I appreciated the honesty, because by the end of our 4-hour work session, I felt so good and I felt so confident about my case. And having those people being willing to support me and encourage me and check in before the trial just was amazing. And I'm grateful for them. And there were many others who wanted to participate but couldn't due to travel time. So it's a wonderful group.
Yeah, you had some really nice things to say about Mark Wagner's directing in that instance. Yep. And I just want to give a shout out to him. I think he's class of 05. So good work going on in Washington.
Yes.
Always has been. So what are we going to talk about today?
Well, I thought I might like to share my experiences representing men charged with sex assault or sex offenses like child molest. I will add that I have listened to many, if not all, of the podcasts. I have thoroughly enjoyed them, learned something from everyone. And honestly, I find that I'm intimidated to appear before this group because it's such an impressive group of lawyers. And they have all had such amazing victories, although I really appreciated those who shared their losses, because we experienced that, and that's what makes it so hard. But what I wanted to share was the work I have done as a woman lawyer representing men who have been charged with rape. And I've done quite a few of those over the years, including trial work.
Yeah, that's got to be a hard place to be. I mean, I'm thinking some of our listeners are sitting out here saying, man, I don't want to do that. So what drives you to be interested in those kinds of cases?
Well, in many ways, I treat the case like I would any other criminal charge, whether it's murder, assault, burglary. But the problem with this type of charge is the defendant is often somebody who has never been in the system before, somebody who might be like my brother or one of my sons who are at college and engage in a consensual sexual situation with a woman, alcohol involved. Next thing we know, the person's being accused of rape and facing years in prison, facing having to register as a sex offender and face an indeterminate sentencing board based upon this one incident when they have no criminal history. So the stakes are so incredibly high for a case like that, that it really, it gives me passion to work them and work them hard, because there are many innocent men out there charged with these crimes, as I have seen and proven to a jury.
Well, and you didn't even mention the alienation of your family and friends, and bye-bye, forget your job. You know, when all that happens to you, you can't hardly find a job. So
yes,
good on you for doing that. And I like the fact that you said this, you know, kind of motivates you and drives your passion to do these cases, because let's not forget, not everybody accused of crime is guilty of crime.
correct. Absolutely.
You know, it's kind of hard to say, well, tell us some specifics, but we can talk generally and get the idea about how TLC methods have helped you and help us understand why we need you in these trenches fighting for these people who are falsely accused of something that really seems publicly indefensible.
Sure. So I was contacted several years ago now by a gentleman who was in his mid-30s. He was a semi-professional tennis player. His family was known in Spokane. His brother was a professional tennis player. He was a very handsome man and quite the ladies' man. He had a girlfriend, but he still chose to do online dating, specifically through Tinder. And
Now, hold on. I was going to just ask you to tell us what Tinder is. Not everybody knows.
sure. And I have learned what Tinder is through doing this work. It is an online dating application. I would say if you asked 3 out of 4 people who do online dating, they would say to you, it's a hookup place. People go there not wanting a relationship, but to hook up. That's sort of the general feeling. Now, of course, that's with folks who engage in online dating. Of course, our jurors, most of our jurors aren't and don't have any understanding about social media. But he met this woman on Tinder. And that was, in my opinion, an important fact.
Okay. Tell us why it's important. Why did you know that was an important thing?
Well, because it gave me a clearer picture of what the alleged victim was interested in and what she was doing and what the relationship was versus what he was doing as well. I mean, truly, at the end of the day, she admitted it was sort of a hookup relationship, a sexual hookup relationship. But it just sort of set the stage for what was going on, which of course is so critical for us in understanding what our cases are about and being able to talk to the jury about, as well as being able to conduct cross-examination on the details. The devils are in the details, and they make all of the difference.
Now, for you listeners who actually attended Woodstock or were born in the late 50s and early 60s, as I was, maybe Tinder is like what I've heard referred to as a meat market. Maybe it's an online meat market. Is that right?
That is an old-fashioned term, Rafe. I haven't heard that in a very long time.
Well, I'm showing my age here.
Yes.
So you knew that because he met this person on Tinder that maybe, perhaps, they were looking to hook up instead of have a long-term committed relationship. Am I understanding you right?
Yes, what it did was it set the stage for what was really happening.
Okay. So what was really happening, Karen?
So what was happening was that they had a couple of dates. The dates involved drinking and sex.
In that order?
Yes, for the most part, drinking and then sex. And the third date, um, they weren't jiving and they weren't getting along. And I think it was becoming clear to both of them they didn't have anything in common. And for some reason, my client said something like, maybe you should just leave. And maybe he wasn't very warm to her and said, why don't you just leave? And she didn't take it very well.
Well, did he say it after they had had sex?
Yes, it was after they had sex. So she didn't take it well, and she was probably humiliated. And so she was drunk and she called her friends, and the friends say, why are you so upset? And it became, why are you so upset, to maybe you need to go to the hospital and get checked. And the ball started rolling at the hospital. Next thing we know, she tells the hospital that she was choked, that she was unlawfully imprisoned, that she was raped, and gave the name of my client. And because my client had a conviction for a general assault in another state, the police saw and they went to arrest him, and he was ultimately charged. He told the police his side of the story, and the police thought, nope, and they charged him with 4 very serious felonies. And the prosecutor insisted on trying the case, again, in part because there were some previous allegations by other women in another state that never went to prosecution, but the prosecutors gained access and they tried to bring that in against my client.
The dreaded extraneous offenses.
Yep. I tried, and of course, if a jury heard about that, that would be the end of the story.
Right.
So, but it was good on the state. They flew women up from California to Spokane for our hearing, our 404B hearing. Fortunately, our judge, following the hearing, said, no, they are not admissible. There is not enough of a pattern. Yes, it was an allegation of sort of sexual assault, drinking and sexual assault, but there wasn't enough of a pattern, and the judge excluded all of them.
Good judge.
So fabulous. That would have made all the difference. So we went to trial. My client...
Also, let me add, Karen, I don't mean to interrupt you, but good lawyering too.
Thank you. So we go to trial, and we decided, my client and I decided, following a focus group, a couple of focus groups, and practice voir dire with a couple of my colleagues here in town, including a dear friend who is the head of the Federal Defender's Office, another woman. We worked on voir dire with my client, and then I did a couple focus groups. And given that, we decided my client should testify. And he did. And he did a very nice job. He unfortunately opened the door to allow the court allowed in a previous non-sex assault from California. And because the client talked about how he didn't trust the police, and the judge saw that as an opening of the door. And I was very upset with my client. He knew it, but nonetheless, I had to take a deep breath and move forward.
Right.
And we did. I will say the reason why I believe the jurors did not, one or two jurors wanted to talk to us afterwards. And essentially what it came down to is her story wasn't believable. It wasn't credible. Her story was inconsistent in places. And this is where I will talk about the importance of, one, I think being a woman does give me an advantage in doing these kinds of cases, because the kinds of questions I can ask another woman, the conversations, and truly a conversation, and not a cross-examine, but a conversation one woman can have with another.
Right.
Even though there are jurors sitting there, and even though the male prosecutor's there, the kinds of conversations we can have are like two girlfriends talking about an sexual experience they had. And it happens all the time. Girls have always done it. They always will. And the kinds of questions I can have and make a woman comfortable to share these things, but also just my experience as a woman and being a woman, the way I look at the facts can often expose that what the woman says doesn't make a lot of sense, or doesn't add up to non-consensual sex. So
I can see your point, because if I'm asking the same type questions that you're doing, I have to overcome that. Well, you're a man, you're just taking the man's position and you're just taking his side and believing his story.
Sure.
And so I can see a very big power dynamic shift with you asking the questions, because you're much less threatening.
Sure. And there is also no one wants to shame the alleged victim.
Right.
I don't want to do it. The law doesn't allow it. A judge won't allow it.
Right.
However, there are ways, if the door is open just a bit, to talk about when she comes to the encounter wearing this sexy negligee, what exactly is she wanting there?
But that's not shaming. That's a credibility check.
Correct. Exactly. And the terms I might use to describe that type of wear are more comfortable, or something that feels more comfortable as opposed to sleazy or sexy, if that makes sense.
Sure it does.
And so the cross-examination, which again, getting to TLC and putting myself in another's shoes, includes how I would talk to myself or how I would look at a situation. And it makes it very non-confrontational and very non-aggressive and very matter of a fact, in a way that it really worked with her. And this particular alleged victim really liked the show of it and liked to stand up in front of the jury and say, well, actually, I was wearing a one piece. And, and she walked in the courtroom wearing 3-inch heels. And, a picture was painted of her and the way she described the scene. And he supposedly threatened her with knives and strangled her, but yet there were no marks on her neck. But of course, there are men who get wrongly charged and get convicted based on these types of facts.
Yeah, that's right.
And we're talking years in prison. We're talking having to register as a sex offender upon release. We're talking never being able to get employed. We're talking limitations on where they can live. There's the ramifications of these cases are so significant. So yes, they require a lot of time to work up. The other piece I want to mention was the presence of social media, including texting, Instagram, Facebook messaging, are also critical in these cases. And for example, texts are only saved for 30 days. So that's one thing. If somebody is defending a client charged with this, you got to get on those texts immediately to get them saved.
What do you mean texts are only saved for 30 days? That's across the board?
Yes. Most phone companies only save them 30 days.
Well, I didn't know that.
Yes, exactly. So unless somebody has taken a screenshot or saved them,
Right.
we don't have them. And of course, if someone is making a false allegation or misrepresenting the facts and they don't save the text and your client doesn't have it for whatever reason, or if it's Instagram that disappears instantaneously, social media can make or break these cases.
Yeah, and I want you to know that it's not just these kinds of cases. Social media makes or breaks civil car wrecks, medical malpractice, everything, because they have these spies that go out here for the opponent and they just mine everything your client has ever put on social media in his whole life, and they use it against you. So, I mean, it's not just these cases. They make or break civil plaintiffs cases too.
Yes, makes perfect sense. And it's very intimidating for those of us who didn't grow up with it to learn and understand how to work with it, because it's all very subtle.
Are you taking a shot at me there?
No, no, the person who refers to meat markets, no, no. Now, the other thing I wanted to comment on as well, because I know we've got a 30-minute session here,
Yeah.
is I wanted to talk about in my opinion, there's a couple things that are critical for these types of cases. One, I think juries at the end of the day want a motive. Why would she lie?
I'm
And
just going to ask you that.
yeah, and if you can't come up with one, and I'm not saying it has to be a motive so strong that in closing you're saying, as I did in the case I was referring to, this was a woman scorned, and I
And
said
she
it
was,
gentler.
hold on, she was scorned by him telling her she had to leave.
Yes.
Okay.
And she was upset, she was angry, and it snowballed.
Okay.
That was what went down there. And that was how we got from the situation with him to her saying she was raped. That's kind of how it happened.
I've heard that hell hath no fury.
Like a woman scorned. Absolutely.
Yeah. So, I mean, I think you're touching a good motive there.
So the motives, just a denial, it didn't happen. Jurors just want to make sense of it in some way, shape, or form.
Yeah.
So sometimes it's, the woman was caught doing something she shouldn't have done. Her roommate thought poorly of her. She was with someone else. She had a boyfriend. It's so complicated, but the jury needs something to latch on to. And I've sort of reached that conclusion based upon my conversations with jurors, following verdicts, and also interacting with focus group members who are so phenomenal, just donate their time to do this. But the other thing I wanted to say was the use of experts. And I'm sure you may tell me this is the same for some of your big civil cases, but I have a sexual assault nurse, otherwise known as a SANE nurse,
Right.
who I retain. She reviews the state's SANE evaluation and examination notes, and she assists me in some of the questions I ask the alleged victim and the witnesses. But inevitably, in most of these cases where the SANE nurse says, oh, this piece of physical evidence suggests it was a sexual assault, my SANE nurse routinely says, you can't tell the difference between if that was a consensual act or non-consensual. So much of this physical, if any, impact that a woman has can be from consensual intercourse. And especially if alcohol was involved, and depending on how experienced the woman was and how experienced the man was, many things show up on a SANE report that do not mean or equate to a violent assault. And so I feel for a jury, especially a jury who hasn't dealt with this type of thing before, having someone explain it that just because the woman has an abrasion on her perineum, well, that sounds awful, right? Well, guess what? An abrasion on a perineum can be something that occurs to a woman who has consensual sex, 5 years into marriage. So, but the way the state would present that evidence can sound very scary and awful and must be as a result of some kind of rape.
Right.
So having that person on my side, on my client's side, is a big help.
I can see that. And we haven't talked about this, so I'm just curious to get your input. I understand that your client may have had hookups with her 2 or 3 times before the final, scorning.
Yes.
And so there's one body of thought that it doesn't matter how many times you've hooked up, no means no, or violence is inappropriate all the time. And, they don't factor in the fact that he's been there. They've been together 3 or 4 times before. On the other hand, my question is, why does a guy who has obviously got a thing going with her 3 or 4 times, why does he need to be violent?
Sure. Well, the argument was that that's his person, and that's who he was. He was this handsome guy. He was used to having a lot of women available to him. She got mouthy or something, and he kind of snapped, and he was just domineering and violent and strong. And yeah, there really wasn't a reason other than he was a big, violent, drunk jerk.
Right. Well, were there physical marks on her, like for bruising, choking?
Well, she had some rug burns on her knees.
Okay. That's it?
Yes.
Okay.
And that, of course, would be consistent with the way that he said and she admitted they'd had sex.
Well, what was the worst piece of evidence for you? What did you fear the most?
What the state does in these kinds of cases is they will add on the charges to make it sound bad.
Yeah, exactly. You said 4.
Right. There's sort of a commonality that often gets charged: harassment, threat to kill, rape 2nd degree, assault 2nd, and unlawful imprisonment. So what the state is doing by adding those together is, inviting the jury to think, well, he must have done something.
Yeah, a lot of smoke here, must be a fire.
Exactly.
It's also unnecessary roughness piling on.
Yes.
And that's why they do it, to prejudice the jury.
And there's always he had a girlfriend. In fact, his girlfriend testified, he looked like a jerk. He was cheating on his girlfriend. One of the allegations is that he collected swords. He had a few swords, as in swords from Lord of the Rings type swords. And she said that he threatened her or swung a sword at her or did something with the sword.
Oh, okay.
And so when the police went with the search warrant, lo and behold, there was a sword.
Right.
So, but it was consensual. And so she didn't have the marks. She was hysterical. When she got to the hospital, she was hysterical. My take was she was really intoxicated. She was really embarrassed. She was scorned. And that was why she was acting that way. It wasn't because she was truly traumatized in the way she was claiming. And that's one has to be very gentle and tiptoe around that.
Sure.
But at the end of the day, you can only tiptoe around so much before you say, this is not a rape. He didn't rape her. He didn't assault her. He didn't imprison her. Maybe he wasn't a gentleman. Maybe he was kind of a cad, but he did not rape her.
Well, we're dying to know what the result was.
Not guilty ×4.
Wow, way to go, Karen. Do you believe that justice was served in that case?
I do. What I will say though, and my client, because there were news stories, Spokane is not a large area. There were news stories. The damage, although the acquittal was printed, the fact is many people saw his name and many people didn't want to work with him.
Right.
And the charges are still there until the 3 years elapse for getting them expunged.
God, what kind of a crazy law is that? You got to wait 3 years after you're acquitted to get your record expunged?
Yep.
That's just meanness.
Yeah, it is. And so, was justice served? Yeah, he was grateful. He broke down in tears. He painted me a picture of the mountains. He was so appreciative. But at the end of the day, even if men, after all that, having to incur the costs of hiring a lawyer, having to hire me, having to hire an expert, having to lose sleep night on end, worrying about going to prison.
Well, and still suffer the consequences that are ongoing to this day.
Yep, exactly. And I know, I haven't talked to him in a while, but he had to leave Spokane to find employment because his name was mud.
Well, what made you know in your heart of hearts or have the passion for his innocence? What was it that made you think this guy didn't do this?
Once I started digging into the discovery and really going through it with him and listening, speaking of a listening exercise, I know that's something you've done interviews on this podcast about truly listening.
Right.
Having done this now 27 and a half years, I tend to go off on my own path, but truly listening to their explanation and being with it and just setting aside everything and being with it and comparing it to the various facts, it becomes clear that does add up. That does make sense. Yes, I see. That is believable. And, the clients, sometimes they protest so much because they're wrongfully charged with a hideous crime. They're upset. But sometimes that sort of anger can become overwhelming for the lawyer because it's just overwhelming, and so, but just once I was with the facts and with him and spent a lot of time with him and spent weekends with him and, voir dire and focus groups, I was absolutely convinced he had done nothing wrong.
And I know the jury could see that. Your passion for your client's innocence shone through. And I just think it makes all the difference in the world. The jury's sitting here going, if this young lady believes him, I can believe him.
Yes. And you're very kind to call me a young lady. Thank you.
Well, you weren't around when Woodstock. Unfortunately, the guy that promoted and started Woodstock died this week.
I know. I was born in the summer of love. I was born in summer of 67.
Oh, okay.
So there you have it. Yeah.
So you can just barely qualify as a baby boomer.
Yeah. Well, I don't know about that, but yeah, I'm close.
You're pretty close.
Anyway, I love doing these cases. They are so stressful and I lose so much sleep and, heaven forbid somebody gets convicted. But I'm just so passionate about it. And I just, it's really a privilege to walk on this path with these clients. But also I'm grateful to the people like my colleagues at TLC who take time out of their busy days to really, even if they don't meet my client, they care for my client and they dig into my client's facts and they roll up their sleeves and they check in with me about that client by name. And I'll tell you, that's what keeps me going.
Our guest today has been Karen Lindholdt. Karen, it's been our exquisite pleasure to listen to you, and congratulations on your success for your client. I've learned several things here today, and I know that our listeners have too. We just thank you and hope everybody listening has good verdicts down the road. Stay healthy, get vaccinated, and stay off the COVID. Thanks again for listening. To sign up for these TLC events, go to www.triallawyerscollege.com and select Register for our course at the top of the menu page. For more episodes of the original Trial Lawyers College podcast, subscribe to us on Apple Podcast or wherever you already consume podcasts. Do you have a topic of discussion that you would like to hear more about? Or are you interested in volunteering to be a guest on the original Trial Lawyers College podcast? If so, please email me at warriorforjustice@gmail.com. Thanks again for listening.